This began partly politically because of the political movement and partly because of 370, my lord. Because that's where we see a coming together of the Constituent Assembly, the governor, the president, all that comes together because there was no merger or standstill agreement. Now, I won't read, my lord, the proclamation of the Maharaja, my lord, of 1948, where he talks of his Council of Ministers. I'll just come straight away, my lord, to what Sardar Patel said over the page in 1.13. In view of the special problems with which the government of Kashmir is faced, we have made a special provision for the continuance of the constitutional relationship of the state on the existing basis. And it's very important to understand what 370 really represented and what the instrument of accession really did. It bound itself to India, but the rest of the process of democratization, my lord, of adjustments, of sharing of power, was never done in the case of Jammu and Kashmir. Even in the white paper, my lord, on the states, there is one paragraph which says, we are not dealing with Jammu and Kashmir. Then, my lord, your lordships will just come to 1.21. On the 12th of November, pursuant to a resolution of the Constituent Assembly resolving to end hereditary rulership in the state, Yuvraj Karan Singh was elected to the post of so-and-so, and dynastic rule in J&K came to an end. Now, your lordships have already been shown how CO 48 emanated from the Assembly of Jammu and Kashmir, Constituent Assembly, and became part of our constitution. This part, my lord, of your lordships, I needn't give you the cross references. Need I, my lord? PDF.
No, need. Before we begin the arguments for this morning,
I'll skip the rest.
I'd like to inform the members of the bar of a very unique
1.24, my lord, I've already read.
We have prepared a handbook on combating gender stereotypes.
So I won't read it again, my lord.
To assist judges and the legal community in identifying, understanding and combating stereotypes about women in legal discourse.
11.
It contains a glossary of gender unjust terms and suggests alternative words or phrases which may be used while drafting pleadings as well as orders and judgments.
Before that,
just lawyers as well as judges.
More for your juniors.
The handbook identifies common stereotypes about women, many of which have been utilized by courts in the past, and demonstrates why they are inaccurate and how they may distort the application of the law.
It might be good.
The intention is not to criticize or cast doubt on past judgments, but merely to show how stereotypes may unwittingly be employed. To raise awareness against the utilization of harmful stereotypes, particularly those prejudicial to women. The handbook aims to explain what stereotypes are and helps judges identify and avoid such stereotypes by identifying language that promotes gender stereotypes and offering alternative words and phrases to identifying common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect. And 3, highlighting binding decisions of the Supreme Court of India that have rejected these stereotypes.
All right.
And can be
This is what I'm trying to do. Not just reading it as a list of dates.
It's been, you have the first page of the document here on the screen, and it's uploaded. It will be uploaded very shortly in a minute or two on the website of the Supreme Court of India.
1.25, my lord. On the 17th of October 1956, the Constitution of Jammu and Kashmir was adopted by the
FAQs for e-filing. And
all the details
in a couple of days, we'll be also uploading simple video tutorials on how to do compiling for members of the bar, which just require a little bit of hand-holding.
A separate constitution.
So it should be here on the website in a minute.
But others, you gave autonomous regions.
For a few minutes.
You bound them together. You expanded it. But this, can the JK Constitution of 1957 be wished away
Yes.
by an amendment to CO2 272, 273 in Article 3. It simply can't, my lord. So one of the big losses is, where is it? It's like Macbeth, the Thane of Fife, he had a wife, where is she now?
No, but Mr. Dwivedi, if you
JK had a
start using it, you'll
constitution,
find
where
it so
is it
simple,
now?
actually.
Has it been subsumed by 273? And when I go to 273, my lord, I'll deal with that. Now, my lord, I come to asymmetrical federalism at 1.30. Kindly change that to multi-symmetrical, as I want to. Now, my lord, all those references are there. But, and of course, I've given your lordship a list.
Please do answer them in your submission. No difficulty.
Which is not repeated here. So I'll come straight away to 1.3. The importance of the Delhi
decision. You can always make the addition in your own language.
I'll take up the second decision first.
You know, Mr. Dwivedi, I'll
Chief Justice, after reviewing the asymmetrical provision described above in State of Delhi so-and-so in 2023,
on Hindu law,
held that regard must be had to the principles of asymmetrical federalism embodied in the Indian Constitution, and that constitutional principle must be given substantive weight to this underlying principle. I'll read that paragraph. Actually, I should read it at the end, but I'll read it now.
3 or 4 compilations by each
this
member of the bar.
variance in the constitutional treatment of union territories, as well as the absence of a homogeneous class, is not unique only to union territories.
It becomes impossible
the Constitution is replete with instances of special arrangements being made to accommodate the specific regional needs of states in specific areas. Therefore, NCTG is not the first territory which has received special treatment through a constitutional provision. But it is another example in line with the practice of the Constitution envisaging arrangements which treat federal units differently from each other to account for their specific circumstances. For instance, Article 371 of the Constitution contains special provisions for certain areas of various states, as well as the entirety of some states. The marginal notes to these articles
instead of that, it becomes so much more cumbersome that we don't know who is saying what.
An overview of a number of states where arrangements in the nature of asymmetrical federalism are made in the spirit of accommodating and specific requirements of regions across the nation. The next line, para 41. I'm not taking your lordships to the PDFs, because this is enough of what I want to refer to. The design of our constitution is such that it accommodates the interests of different regions, while providing a larger constitutional umbrella to different states and union territories. It preserves the local aspirations of different regions. Unity in diversity is not only used in common parlance, but is also embedded in our constitutional structure. Our interpretation of the Constitution must give substantive weight to the underlying principle.
You feel that, oh my God, I might miss something because things come
how we approach the Constitution as has been done otherwise. Now, my lord, I add to this, my lord,
the give 30 minutes time and 1 hour's time. So
huge number of precedents, my lord, what is called transformative constitutional.
It's the most complicated case. They only hear you for 30 minutes.
1.36.
Interventions of the court.
No, we are far more advanced technologically. Actually, trust me, we are almost at the high end of the curve.
Navtej Singh Johar, of our magnificent constitution is to make right the upheaval which existed in Indian society before the adopting of the constitution. The court in so-and-so observed that the Indian constitution is a great social document, almost revolutionary in its aim of transforming a medieval hierarchical society into a modern egalitarian democracy, and its provisions can only be comprehended only by a spacious social science approach, not a pedantic traditional legalism. The whole idea of having a constitution is to guide the nation towards a resplendent future. Therefore, the purpose of having a constitution is to transform the society for the better, and this objective is for the fundamental pillar of transformative constitutionalism. Then, my lord, no library justice as he then was, my lord. in the 219.
Start again, my Lord. I appear for the JK
Delhi
People's
decision.
Conference,
The Constitution is a transformative
in writ petition
The realization of
1165
this transformative potential rests ultimately in the ability to breathe life and meaning.
A question that your
into
Lordship
its
put to
abstract
Mr.
concepts.
Sibal was,
For above
have
all,
you
the
challenged
Constitution
the
was not
presidential
intended by its draft
proclamation
persons,
of 19th
was intended,
December.
sorry,
We've challenged
by
the
its draft
suspension,
persons to be a
and that is
significant
very
instrument of
important to our
bringing about
argument
social
in
change
Article 3.
in a caste-based feudal society.
There is also
witnessed
another
by centuries
position,
of oppression and discrimination against the marginalized.
1068
As our constitutional jurisprudence has
actually
evolved,
challenges
the
the
realization of the transformative potential of the
2068, right?
Constitution has been founded on the evolution of equality away from its formal underpinnings to its substantial potential. My Lord, I cite this for a reason, my Lord. When this hearing began, my Lord, it appeared to me that we were reading the Constitution as if it was a statute. For a long time, my Lord, we were going to this word and this proviso and that proviso, my Lord. That is not how constitutions were meant to be read or to be transformed. Then, my Lord, if your Lordship will come to this question 1.41, I won't read it, my Lord, because constitutional morality is also mentioned
as well from my Lord
in various
Chief Justice,
judgments.
that this oral submission is in the nature of a
when you
dialogue,
refer to Pratap
and a very important dialogue,
Constitution, etc.
which even the US Supreme
Now, my
Court
Lord,
doesn't
straight
have.
of NCT
They assume
versus
that
Union
everything
of
is
India.
read, and
If
there's a
the
bit of
moral
question and
values of
answer,
our
and that's it.
Constitution were not
And it is because of the
upheld
nature of the dialogue,
at every stage,
we have
the
to, on an
text of the
ongoing basis,
Constitution may
answer
not be
what
enough
fell from your
to
Lordship
protect
as
its
well.
democratic values.
I'll give your Lordship
In
an
order
example.
to truly understand
My Lord, the
what
Chief Justice made a
constitutional
reference
morality reflects,
to
it is to answer necessary to answer
249
what
and
is that
252.
Constitution
Of course,
trying
they are
to
of
say,
different genre.
and to identify the
nevertheless,
broadest
my Lord,
possible range to fix the meaning of the text.
Question is very, very important.
Constitutional morality does not mean allegiance
build the diversity
to the substantive
argument
provisions and principles
and whether
of the
there is
Constitution.
transformative
It signifies the
constitutionalism,
constitutional
whether there is
culture which
a
each
basic
individual in the
structure,
democracy must
whether
imbibe.
that's a lost
Pratap
cause or
Manu
not.
Mehta identifies certain
Then, my Lord, your
features-
Lordships had asked
features of
questions about
constitutional
Article
morality,
31D.
chief amongst them being liberal values
And
which
whether
govern the making of
Article
India's
370
constitution,
subclause 3
and created
survives.
expectations.
Now,
from
this
the
is
polity.
important because it's
one of
been
the
used only
essential
twice.
features of
It was
constitutional
used
morality.
in GO 44.
Thus is the ability and
now it has
commitment
been
to
used
arrive at
once again
decisions
in
on
GO
important issues
273.
consensually.
Now, if it doesn't
It
survive,
requires,
my Lord, how can it be
despite all
used in this
differences, we
particular
are part
way?
of a
We have to
deliberative
answer that
exercise.
question for your Lordship.
It is going to be my submission.
In addition
my
to
Lord,
that, my Lord,
that this deliberative
there seems
exercise,
to
my
have
Lord,
been some
has not taken place.
confusion or
with the changes of
misunderstanding
JNK Constitution.
on the status of merger agreements.
Now, Mr. Sibal, my Lord,
The question
had a
that fell
number
from
of
your Lordships was
questions that were asked
that
in
once
Parliament
the
till
instrument
last
of
day.
accession is
Your
over,
Lordship has seen that.
sovereignty is
Are
complete.
you changing 370? The
Our
answer was
respectful
no, no,
submission,
no.
my Lord,
And
on
suddenly,
this,
my
which I
Lord,
will
out of the
elaborate.
blue,
I've done it
to
in
enter into
my
Lord,
Like Mr. Zafar, I'll hand over
this,
that note, my Lord, to
my
your
Lord,
Lordships.
consultation of concurrence,
370,
my Lord, is fundamental.
as far as the instrument of accession
to the
is
manner in
concerned.
which we read
It deals with
constitutions
external
and how each
sovereignty.
provision comes into place.
Kindly bear this in mind, it's very important. External sovereignty is lost.
Then, my Lord, I will just read, my Lord, the NCT decision.
A few exceptions here and there.
That's the earlier one, my Lord. While interpreting the provisions of the Constitution, the safe and most sound approach for the Constitutional Court to adopt is to read the words of the Constitution in the light of the spirit of the
But
Constitution.
internal sovereignty
So
is
that
not
the
lost.
quintessential democratic
That is why
nature
in
of our
Premchand,
Constitution and the
they say
paradigm of
that monarch
representative
was still an
participation
absolute
by way of
monarch.
citizenry engagement are not annihilated. This court must adopt an interpretation which glorifies the democratic spirit of the Constitution.
So what the purpose
Constitution
of
has
the
mandated a
standstill
federal
agreement
balance,
was,
wherein
what system
the
would you
independence
have
of
in the
certain
meanwhile?
required degree is assured to the state governments. As opposed to
State-
centralism,
the Raja
a
of,
balanced federal
JNK didn't
structure mandates that the
didn't sign a standstill.
union does not
The records
usurp all
show
the
there was some
powers,
toing and froing and eventually, which means
and
he
the states
retained all
enjoy
his
freedom
power.
without
So as
any
far as
unsolicited
internal
interference
sovereignty
from
is
central
concerned,
government,
the
with
standstill
respect to
was very
matters
important.
while exclusively falling
Because
into
all
domain.
the powers of the
So this is
Maharajas
the
and
approach, my Lord,
coming states
towards constitution
retain their
to
internal
multi-symmetric
sovereignty.
federalism. Now, my
Now
Lord,
come to the
I
merger
will take your
agreement.
Lordship straight away, my Lord, to 370.
The merger agreement is important, my Lord, because it finally indicates the extent of internal sovereignty.
I think at some stage a question
there was no standstill agreement.
Want any protests made?
And if there was no merger agreement,
I just want to take your lordships to 2.15 at page 221 external. My lord,
so
there
I take
is
370
literature that could fill a library,
a substitute
on the
a
protests over
constitutional
370.
substitute for a standstill
And then, my
and
lord,
merger
the
agreement.
state autonomy committee,
Without which, my lord,
read
we are
this out.
lost. And I'll explore that, my lord, later when I come to 370.
And of course, it goes to a slightly further extreme, my lord.
Your lordship
but
also,
this is, my
my
lord, the constitutional
put a question
understanding,
to Mr. Zafar Shah,
which is not too dissimilar
that on
with
the
other
4th of
federations.
August,
I won't read it, my lord. I've just pointed it out to your lordships.
what were the autonomies that you were going to lose?
Once again, my lord, I've reproduced here the debate.
My lord, one answer to that is everything.
I'm not going to read
but
those out.
I will
my lord.
indicate what these
My younger
autonomies
speech has been read
meant
out
and
to
what
your
was
lordships,
lost
my
for
lord,
Jammu and Kashmir.
2 or 3 times.
Which comes back to Justice Paul's question. Are we
It's just that on page 224, whatever I've highlighted,
the answer is no, my lord.
Again, the government of India has
and
committed
it has to
themselves to the
continue
people of Kashmir
to
in
preserve,
certain
my lord,
respects.
the
They've
federation
committed
and the
themselves to the
conditions
position
under
that an
which
opportunity
the
would be
federation
given
was
to the
created.
people of the state to decide for themselves
let me begin
whether they will remain with
what I
the
began
Republic
with
or
the other day,
go out of
Lord.
it. We are also committed
And
to
that is
ascertaining the
that
will
we
of
have
the
the
people
greatest
by means of
diversity
plebiscite,
in the world.
provided that
Take
peaceful
many
and normal
continents
conditions
together,
were restored. And the
take many
impartiality of the
countries.
plebiscite could be guaranteed. We have
diversity
also agreed
is
that the will of the
unparalleled.
people through the instrument
That
of
is
the
why, my lord,
Constituent Assembly
Professor Ravinder
will
Kumar,
determine the constitution of the state.
I asked him, I
as
said,
well
what
as the
should I
sphere
say in my
of
Colombo lecture?
union jurisdiction.
He said, say that
over
the
state.
Constitution of India
This is the commitment,
constitution
my lord,
for civility
that lies behind Article
with
370.
many nations and many cultures.
Then, my lord, at the bottom of the page,
And this is what makes our constitution more
only an
exciting
interim
than any
arrangement
other.
is possible, not an arrangement which could at once be brought in line with the arrangements that exist.
On the question of diversity,
now,
I
if you
was
remember
taking
the
your
viewpoints
lordships
I've mentioned, it's an inevitable conclusion that at the present we could establish an interim system is an attempt to establish such a system. Then, my lord, I will skip, my lord. I have
done a list which I'll give to your lordships, my lord.
But I was going to invite your lordship's attention to Article 3 first. The JK Constituent Assembly, my lord, 11.21. I'm coming to page Article 203, my lord. Sorry, 217.
But I'm going to read one important aspect of it, my lord. And that is the proviso which says that before anything is done under Article 3, it is mandatory for the President to refer the bill to the legislature. Mandatory. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370 which have to be fulfilled by condition precedents. Now, on Article 3, my lord, the proclamation of 19th December virtually created an amendment of Article 3 by taking the condition precedent out. Mr. Sybil read all that to you, but I want to refer your lordships, my lord, to that particular part of the proclamation. My copy, somewhere here. Your lordships will find this, my lord. Like Mr. Dwivedi, I have no problem with what your lordship is doing. We just have to learn and catch up, my lord. This your lordships will find in volume 3 documents.
Page 92.
And the PDF, my lord, Sheikh Abdullah's speech has been read.
Just give it to you.
But this is their understanding in the absence of a merger agreement.
Now, my lord, I want
earlier,
to take your lordship straight away.
And it's very establishing the relationships.
And in that portion that I've highlighted, this arrangement involved a division of sovereignty, which is the normal feature of federation, beyond the powers transferred to it by it to the dominion. The state enjoyed complete residuary sovereignty, which is what is reflected in the JK Constitution. So, my lord, the instrument of accession says list 1, list 3, they have their place, but we have all the residuary powers. Therefore, control over the state lists, my lord, as far as they are concerned. Then, my lord,
ultimately, everything boils down to this. Of course, the Constitution itself and
when the draft Constitution, my lord, was introduced,
now we have.
In case coming to 11.25,
Dr. Dhawan's
231 and 232.
Advocate, they'll just put it in and what do we call this? This plastic made up.
Just at 232, my lord, just above 11.26. By this I mean that all these special constitutional privileges which our state enjoyed prior to 1953 are enjoyed by her even today. In other words, the state enjoys the same kind of autonomy which it stood prior to 1953. Therefore, to say the instrument of accession wiped things out, my lord, is simply not correct. Now, my lord, 11.28, I've already read it out to your lordships, my lord, because it imposes a limit. One question that was put, can 370 be amended or not amended? Is it there permanently? Mr. Sebal said that's not before your lordships, but at any rate, it may not have been a sufficient answer. There is a proviso, my lord, that was added by CO 48. CO 48 is a foundational document, my lord. And that is at 11.28, provided further that no such amendment shall have the effect in relation to the state of Jammu and Kashmir unless applied by the order of the President under clause 1 of 370. In other words, after you go through the amendment process. Your lordship will see that there is a condition precedent in Article 3. And this condition precedent, my lord, was added to by CO 48, which I'll show to your lordships in a moment, my lord. Which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state. Now, my lord, I take your lordships to this notification, C subclause 2. Now, my lords, so much of the first proviso
somebody's cell phone triggered.
of Article 3 of the Constitution,
the microphone
as relates to the reference by the President to the legislature
there, which I didn't want.
and the second proviso
I was talking to my colleagues.
so that much of
I hope they will be
clause 2 of
excised.
151,
No, that's what
which is
I
about
went to
audits,
him and
of the
told him that your
Constitution,
whispers
as
are
it relates
also
to laying
being
before the
recorded.
legislature of the state of the report
We will
submitted
deal
by
with
the
all
governor
that.
to the controller.
With a pinch of salt, my lord.
You will see that the opening sentence says the following provisions are suspended.
But it's quite accurate. Huh?
In other words, my lord, a mandatory provision of Article 3.
I shudder to think, my lord,
Whether it applies to
if
Kashmir
this
or
was the
elsewhere,
case when
my
we
lord.
were arguing Babri Masjid,
It's
what would come
suspended.
in the transcript? Such a huge amount of exchange took place, my lord.
It's not a question of just laying before
No, my lord.
Parliament as a substitute.
Therefore, my lord,
Article
how do you
3 and
amend it?
Article 370 does not tolerate substitutes.
you amend it through the 368 process. But there was,
No, my lord, what
in
does this do?
48, my lord, a
This is
provision
not, my lord, that can be done under a
You will
proclamation.
then go to 370 and follow the procedure in 370.
Under 356.
And that's very important.
It is a
my lord. Your lordship
constitutional
asked, what was lost
amendment.
from the 4th of August? This is something that was lost. And they didn't even use
Which
the
is
amendment
subversive
power,
of the Constitution itself.
which is the only power available to them, my lord.
If this suspension fails,
Delete
my lord,
370.
President's
Not
rule
the
will
circuitous
fail.
process that they used in 272
And its
273.
extension, my lord, in July will also fail. You have amended the Constitution, albeit to all states and certainly to Jammu and Kashmir. And this mandatory provision takes us to the core of the mandatory requirements, my lord, of Article 3.
Yes, Doctor.
No, my lord,
Because the entire JK
235
or
11.32
Reorganization Act
onwards emanates
My lord,
from
your
Article
lordship
3 and
conferred,
Article
that
4.
took time as well. Happy though I am
Take
that
away
your
this
lordship
condition,
did
my
not.
How do
My lord,
we
I'm
deal
going
with
to be
this,
super quick.
Article
Just give me that
356 1C.
Now, my lord, here are all the cases.
Your lordship needs
Sorry,
to
my
go
lord,
to
Article
Premnath call, which I've
356
summarized, my
1C
lord,
says
in 11.33.
that if the
Because it actually
that you may make
explains what the situation was
proclamation
after
where a situation has
1950.
arisen that the government cannot be carried on in accordance
When
with
there was an
provisions
instrument of
Constitution
accession,
any
but no
state.
merger
And then
agreement.
C.
Make such incidental and consequential provisions as appear to the President to be necessary or desirable on page for giving effect to the objects of the proclamation,
236, my lord.
including provisions for suspending in
submission,
whole or in
my lord,
part the operation of any
from
provision of
Premnath
the
Kaur
Constitution relating to any
The
body
application
or
of
authority.
370 of the Constitution to the state of JK also does not impact the plenary powers of the
So the
Maharaja.
President has a power
The form
to
of the
suspend,
Constitution
certain
to be
provisions
applied
of
to
the
JK
Constitution
was a
during the
matter left
operation
to be
of
determined
a
by the state
proclamation under
Constituent
356.
Assembly.
The suspension
And
in this
until
case
such
goes
decision
beyond
was taken,
supplement, my lord.
The constitutional relationship
It goes to
between
actually
the Union
taking
and the
out a
states
mandatory
was
provision.
governed by the terms of the IUA. So the internal, my lord, relationship had to still be determined under 370.
Of course, my lord, Article 4 says that any change that is made, now, my lord, will be
But
treated
an
as
argument has been made
as
on
not
the basis
requiring
of
an
Quran,
amendment. But
Compal,
leave that
etc.
aside, my lord.
What is the meaning of modification? And they say it's
How
very
is
wide.
3 and 4 to operate?
But my lord, your
after this?
lordship has to read it in context. And that is when the matter was not referred to the 7-judge bench, my lord. Your lordships took the view that please read these decisions in context.
The presidential
Don't
duty,
read them
my lord, has
outside
to
the
be a little
context.
more careful. Because this was tailored way back in 19
No, my lord, I'll come to
December 2018
70, my lord.
to start a process, my lord,
What I've done in the meanwhile, my lord, is
of
done a
amending the
short
Constitution
page
for the
and a half,
purposes
my
of
lord.
which, as
But I'm not giving it now because your lordship may
Normally when the
introduce the guillotine
legislature,
earlier.
of course it's the Constitution, uses the
Now, my lord,
expression
kindly come to
means
370.
and includes. Here it's not means, but it says make and includes. When means and includes is used by the legislature, it's an indication of, does that begin
Expand
with the
39,
power?
Dr. Dhawan?
So
Sorry, my lord?
when the Constitution says,
sorry.
begin by saying
What
make
you were referring to your
incidental or
submissions?
supplementary
Lord, I'm not going to
provisions,
repeat what's in
and
the
then says
sub-volume. I'm going to just, my Lord, stress what is not in the submission.
To widen the
I've
ambit
stressed
of
orally.
what was stated earlier, namely the earlier part says you will make incidental or supplementary.
No, my Lord, we need not be troubled.
But then it says including.
At all.
So including would mean
that has been the great,
what was otherwise not
this is a temporary provision
or incidental
it's
provision.
It's temporary to the extent
within the ambit of the presidential
that 370
proclamation,
indicates,
isn't it? Because
therefore, my
suppose
Lord,
clause C
in my personal view, my Lord, 370
and didn't have
subclause
and including.
2 and 3,
it's not and
which
including,
deal with the Constituent Assembly, my Lord,
with the word proclamation.
the operation of any provisions of this
So
become more
if the last part of Article 356(1)
they have
was
invoked
not
this, my
there,
Lord,
you could have
in
challenged any
CO273.
amendment of the Constitution
all of a sudden,
on the
the provision, my Lord,
that you don't
which
have
is
the power to make an
constitutionally
amendment of the
beyond
Constitution in the guise
the
of
extension
making
of
it
the
incidental
Assembly
or supplementary
has
provision.
suddenly been used. This is the basis of our challenge, my Lord. In our petition, we have challenged only the suspension.
My question is this.
CO273.
Suppose the President in a proclamation suspends the operation of any provision of the Constitution.
CO44, is it?
Is that amenable to a challenge?
44 is the only time, my Lord,
incidental or supplemental?
370 subclause 3
are these words of
in
widening the ambit
1952
of the first
and now,
part of
my Lord,
356
in the year 2019.
so as to be immune from such a challenge?
This, my Lord, has so, my Lord, what remains of 356? That is, for the governor, you read the president. For the legislature, you read the legislature. In our submission, but I've never seen a provision in any proclamation, my Lord, subclause 1, throughout, my Lord, these decades, which actually uses the supplemental and including. I've never seen it take away a mandate to be read in context. And what are the provisions exceptional? Now you can read it together in one way, you can read it together in the other way. It's been read. If you expand, it says follow the instrument 356C, my Lord, accession. Then you will say that the president, as far as consultation is concerned, for the rest, to amend any part of the Constitution as part of the supplementary provisions.
Can you, for example, say that there will be no judiciary in the state?
That's right, my Lord. And the same is true, my Lord, of the
Oh yes, the proviso says
371. Supplementally, those provisions, my Lord, 6C has to be governed by mandatory provisions which it cannot dilute. Which then talk of consultation and concurrence again. The reason why I said, my Lord, that 370 could not be tinkered with during President's rule
Dr. Dhawan, the proviso
is because there is a mandatory requirement as it was in Article 3.
That if Parliament, if the Constitution wanted to exclude a particular power from the authority
about
to suspend the provision of the
Constitution and concurrence,
then that has been specifically
you can't say we wiped out the Constitution,
so
we wiped out all the treaties, so that 370 is gone.
Pertaining to a high court.
Amend it.
Or you will not assume to yourself as the President any of the powers which are vested by the Constitution in a high court.
Mandatory provisions which survive in 370
under Article 356.
Are violated.
So where it wanted to
and they can't be done under President's rule for a very simple reason.
It has done so in the form of the proviso.
Right. The state
we now say that, well, apart from the proviso,
consultation with the government of the state is declared by the president
or would that be reading into
other matters in such list with the concurrence of the government of the state?
I think,
of course, provision 1 in this article shall apply in relation
appears to the president to be necessary or desirable for giving effect to the objects of the proclamation. So there has to be connect and a nexus with the object.
370, by far from being a relic,
that's a restriction.
Is in fact relate to there in the merger of agreement read. With the whatever is required to materialize, I say this it must be related to that and parcel, my Lord, of the multiple federalism that exists. You can't use these words, my Lord, necessary or desirable to the discipline carte blanche of powers of the president. Could he have under and that's what Damnu, suspended? Part Damnu, your Lordship will get the. It has been done. Also says you can't do it. That fundamental rights. I asked, come back to my broader principles. Could he have done all that? While President's rule, therefore, my Lord, it has to be given even with the caveat of regards the High Court. You can't it has to be given a limited meaning where your Lordship can't, my Lord, do away with 370. For a very simple reason, every state that has been created under Article 3 and 4, this has been treated as Parliament can do this and the President can do this. It says a caveat that must be done by the government of JK, which is not Article 3 and the Azad's government. That all that it requires is a reference to the legislature. It says, and the union is not bound by the Council of Ministers. Those, my lord, when I do come to that is fundamental to the operation. I'll run through them very fast because I don't need to. So you don't take out the books or refer to the cases. Council of Ministers. Can you this, to my mind, my lord, the way it was introduced in Parliament process by Mr. Amit Shah, that you simply do it by saying we're using 370 and this is how it's done. In President's rule, my lord, it cannot be done. There is no tearing hurry, my lord, in our Constitution to say that the amendment power can be used and abused whenever you want it to. I'll show you the. My lord, I want to show quickly two decisions, my lord, on why the merger is separated from. It is in volume 6, my lord, of the cases. And the case is Pramod Chandra Dev. It's at page 1587. PDF. And I want PDF 144. The steps that were required on the inclusion provisions for suspending in whole or in part the operation of any provisions of this Constitution relating to any body or authority of the state. Now, my lords, and then according to your lordships to page 1596. This further subscribes.
Dr. Dhawan, which volume?
The extent of, sorry, my lord, volume 6. The presidential This is volume 6. Item number 10, page 1587. 356 is an exception. It overrides. It starts at 135, and I'm taking your lordship to 1596. It collapses democracy in a state. At 144. My lord, this is in para 10, on page 1596, my lord, the bottom of the page, my lord. This was, my lord, some.
What PDF page will that be actually?
144.
144.
It says of the instrument of accession, Lord, in the last 5 lines of page 1596. Does your lordship have it? This accession, that is, instrument of accession, did not affect the continuance of sovereignty of the rulers entering into the agreement, save as provided by or under the instrument of accession. So there was no external sovereignty was lost, my lord, but internal sovereignty, my lord, remained where it was. And then, my lord, going over the page at 1597, my lord, 4 lines from the top, the second step was the signing of what has been termed the standstill agreement, the form of which appears in the white paper. Chips. Because if the presidential proclamation does something that is irreversible, signs the standstill agreement, that is a test for the continuance in time of all subsisting agreements and administrative arrangements in the matters of common concern between the states and Justice Khanna is right, my lord. The first when he emphasizes necessary or desire of the Indian states into the Indian in relation to was the accession of the states as I pointed out. The second phase, if this proclamation followed on the merger of the states, then its extension, my lord, as a result of the merger in July is also back. Now there was no merger parliamentary extension for a further 6 months. So where was the merger agreement, my lord? Either we continue the sovereignty, it was said, my lord, in Premnath call, or we say that this is the essential step by which, my lord, internal sovereignty and internal arrangements are worked out. Then it says, my lord, a little further down,
But 4 lines below that, my lord. As a result of the merger agreement signed by the rulers of these states on or after 14th December, but before the 1st of January 48, the dominion of India was vested with sovereign powers, and the ex-rulers were left only with their private property and their annual privy purses. This was the effect of the merger agreement. And it's all there in the white paper of the states, which I don't want to go into. So where was this loss?
Article 358
internal sovereignty
suspends Article 19 during the proclamation.
In Article 370, my lord.
Not beyond. This is now, my lord, and
the only two other
see that further when I present CO 272 and 273. They go
and
well
that is why, my lord, I
emphasize, and the genesis of all this
is the repository of the merger agreement read with the instrument of accession.
Even assuming
in this very volume, my lord, I want
goes for 1 year,
refer to one other.
It takes away conditionalities which cannot be taken away.
Which is the first privy persons case, my lord. It starts at
PDF.
It starts at PDF 390. And I want to take your lordship straight away. Later, my lord. I'm sorry. Of course, the amendment came later in taking the Privy Persons Amendment power away.
Page 3.
So, my lord, I'll take.
I'm a little
loud. We're still on volume
I'm
6,
not used to this,
and I'm taking your lordship to PDF 457.
Like my predecessors. Now, my lord, I'm going to place
just one small paragraph.
No, classrooms are very soft.
111 on page 19.
Classrooms are a wonderful exchange with students.
PDF 457.
Unparalleled. Just as this is an exchange between the bench and us, my lord. And it is the nature of this exchange, my lord, that we must honor. Under limitations of time, of course, my lord.
11, Mr.
But we must, my lord, honor this exchange as the most important part of arguing in this court.
The plea raised by the union must be considered in the light of these developments. The political developments and the history of negotiations and agreements were certainly not intended to be an exercise in futility.
In Article 3,
the argument that the parties to the instruments were entering into a solemn undertaking intended the arrangements to be temporary and likely to be
your lordships will see
the unilateral
that because your lordship raised the question
must be rejected.
What did you lose on 4th August? After 4th August.
This is building on Mr. Sibal's argument, my lord. The unilateral act,
CO 48,
the assumption you don't take into account history. So the argument raised by the union,
PDF 13, my lord,
that this is an exercise in futility going back. The response is the argument that the parties to the instruments were entering into solemn undertakings intending the arrangements to be temporary and liable to be set at naught by the unilateral act.
If your lordships were to come to page 10,
must be rejected
of volume 3.
I'm actually done.
406, sorry, not external.
And PDF?
PDF 13.
Submission, my lord, which I will hand over and go through it. One of my arguments, my lord, whether it is done by transformational morality, my lord, because of the anti-Semitism, or whether it's done by basic
in a sense, the 54 order,
transformational morality, in my view, is a part.
And 370, my lord,
that 370
that the Constitution,
the basic structure,
as relates to Kashmir.
As a substitute for the merger agreement.
They were brought in by the Constituent Assembly.
As an interpretation, my lord. Just hand over that.
Now, I'll just read out that particular portion, my lord, so that I complete the 3-4 argument before I go into the business of how elaborate our Constitution is. 356, my lord. At the bottom of that page, my lord, 406, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of volume 1 of the submission shall be introduced in Parliament without the consent of the legislature of the state. The PDF number is 267. It puts in a conditionality, my lord. My lord, I put in a table not just to circulate it, But to show how President's conditionality exercised in Section 92 is emanating from the state itself. My Lord, it is my respectful submission. They cannot be exercised in whether tandem. All this can be wiped out by CO 272 and 273 is another matter. I'm going to make one further proposition, my Lord, about President's rule. Lest I forget, I'll refer to it later, my Lord, if I can. As it was, my Lord, Governor's rule had taken place, and now President's rule was imposed. On that, my Lord, if your Lordships will see, I've given, my Lord, all the cases that I want to cite. I won't bother your Lordships with them. Except, my Lord, the page 276, which is a wider proposition, is this, 4.25. That during President's rule,
I'm sorry, Mr. Nehru.
Article 3 and 4 and 370 my submission. I'm now winding up, my Lord.
Page number?
Mercifully. 276 cannot be invoked.
Article 3 and 4.
An important aspect, my Lord. Why? Because they have conditionalities there. You can't. And remember that conditionality is just the legislature of the state. 32 was not the government of the state. But I'm the legislature becomes Parliament. 4.25. The governor becomes president. Therefore, the conditionalities that exist in 3 and 4 and Article 370, neither Parliament, my Lord, nor the President,
yes,
it is open to the court in exercise of judicial review for the conditionalities that exist, whether the governor's report is based on relevant material or not. 3, 4 and 370. Whether it is made bona fide or not, through that process, and whether the facts have been duly verified or not.
Such a broad proposition with regard to Article 3.4
is what your Lordships have indicated on the extent
not be
of judicial
correct
review.
In terms of the language used of clause 3 to 356.
Now what has happened in this case, my Lord, and your Lordships,
it can happen.
As a Nagaraj can lay down conditionalities for the exercise.
Two states and which is impossible to resolve.
All the documents must be made publicly available
with regard to boundary or something.
If in this case, even the governor's report,
if you're making a broad proposition like that,
I'm responding.
It's very difficult.
It's very difficult to accept. I'm responding.
Because we can be varied situations.
So when your Lordship says 356 is justiciable, what are the contours of this decision about process and substitution? Because full, frank and complete disclosure, subclause 1, my Lord, has its discipline and to the people. Just as 3 and 4 has its mandate. This is
370 for the time being, but a broad proposition that Article 3
that is why I say, my Lord, the entire exercise of President's rule needs to be examined by our Lord. My Lord, the Parliament cannot be, and I'll show the debate more on this, and Amit Shah introduced this, my Lord, in the Lok Sabha. No, my Lord, I'm going to give Parliament cannot be a substitute for the legislature of the state. My Lord. Give it to the other side. That's a very narrow proposition, my Lord. I've been prompted. Because this, my Lord, nicely, is the substance of what I've added to my written submission. And when Mr. Sibal talked about the political uses and abuses of the Constitution, then Proclamation 19th December, my Lord, is an abuse of the Constitution. And it would be a further abuse of the Constitution if we substitute for legislature Parliament. India has a multi-symmetrical constitution to be interpreted as transformational.
So let's not confuse the two.
Sorry, it's unique.
There's a difference between existence of power.
And that is why your Lordship insists on these transformations, despite the many amendments, despite the leg. There is a power, no doubt. This is a multi-symmetrical exercise is equally fundamental. My second submission, we can't wish away the instrument of accession as being subject to conditions purely nominal. The loss of external sovereignty. However, now, Lord, when standstill and merger agreement finalizes the internals are all there in my written submissions. I'll take your Lordship very fast through them. And that they said you have to refer whether you like it or not. Likewise, Punjab, 370 is the result of a binding historical legislature of the instrument of accession deals inter alia with conditions of external sovereignty, but in the absence of standstill and merger agreements, 370 represents a substituted, constitutionally consecrated merger agreement for finalizing internal and the Constitution says no bill can be introduced. interactive, sui generis constitution. It's a complete bar, unlike any other state. Because we have to understand unique and part of the limitations of president's democracy and federalism. For basic structure, my lord, transformational constitution. My lord, limitations. That during President's 371, you may have the power to do whatever you want in 372 and 3 have exhausted their 70. But the process, my lord, are conditions because which can't be substituted by simply saying the first time the governor will now become the president was used and the legislature will become parliament. This process of substitution, my lord, the Constituent Assembly is gone. And the substitution is for the Constituent Assembly.
Can Parliament enact a law during the subsistence of a proclamation under Article 356
subclause
in exercise of the power under Article 246
after the Assembly
or in respect of a stateless item?
Look, they can pass a law, my lord. No doubt about that, subject to all the limitations that exist.
Right.
Except, my lord, there is when it passes a law power. Under Article 3 and 4, subject to it must observe the condition more than what has been said.
In other words, what you are trying to, your argument would be
subject to its two provisos.
That while Parliament can exercise the lawmaking power of the state legislature during the subsistence
Article 3, 4, and 370 contain mandatory requirements on information to be laid before the House and inter alia requiring concurrence and consultation. Unfortunately, the mandatory requirements of Article 3 for sending the bill to the legislature
under the second
was suspended by the presidential proclamation of 19th December 2018, which is ultra-vires and taints both the declaration and the extension of President's rule in 2018 and 2019.
Because then we are creating an exception.
Then, my lord, on President's rule, the President's rule provisions of 356
give a purposive interpretation to that provision.
And 392
one part is
Section 92 of the JK Constitution
we are then creating an
cannot be imposed in tandem.
1B.
3 and 4 and 370 cannot be invoked during
that the powers of the state government are vested
since they require the existence of a legislature and state government, for which the President and Parliament cannot be constitutionally
then 356(1)(b) says, declare that the powers of the legislature of the state
then President rule as required
by or under
S.R.
the authority
Bomai and
of
Rameshwar
Parliament.
Prasad is justiciable, requiring objective basis, which includes the governor's report, and all material should be placed
those powers which are referred to Articles 3 and 4, which are powers of the legislature of the state. No doubt they are powers of the legislature of the state.
The difference between the legislative powers
I was just telling my colleague that you have really summarized it precisely all that you've argued. You've taken down what you've
argued. If your lordship will see 357,
certainly.
And then I'll sit down. And that's the promise.
But it says declare that the powers of the legislature of the state.
Article 370.
The powers of the legislature.
So I've said all the material. Legislative powers. Article 370 can be
powers under Article 246
amended, subject to the caveat in CO48 that all amendments relating to JK must follow the procedure in Article 370 to Article 257. It is not enough in 273 saying all the treaties are out and the Constitution is gone. How can a Constitution disappear like this, my lord? Many federations, my lord, have two state constitutions. 357(1), my lord, and JK, because of its nature, my lord, declares that the powers of the legislature shall be exercisable by or under the authority of invalid as being it shall be competent for Parliament to confer on the President the power of the legislature to under 3 and the state to make law beyond the mandate and to authorize the President and in violation of the process of Article 3 as they may wrongly suspended the power so conferred to any other authority. The Parliament or the President or any other authority in whom such power to make laws is vested. My lord, you are answering your lordship's question. To make laws conferring in
yes. That's point 9.
And imposing duties for authorizing the conferring of powers and this is my summary account upon the union or the office. The loss of statehood and authorities thereof by degrading it to the President to authorize that when the people also the indirect abolishment of the JK expenditure from the consolidated fund of the state, loss of residuary the sanction of such expenditure, loss of territory contrary to the JK more important the law is 2. Section 4. Any law made abolition of mandatory informatory concurrent legislature by Parliament or conversion of statehood or other authorities
without adequate so-and-so, especially for JK and Ladakh, which Parliament or the President or such authority without a proper amendment and for the issue of the proclamation and concurrent procedure of Article 370, competent to make CO48 after the proclamation added C368. The right of permanent continue in force until altered or repealed on the right to property and to vote. Because 31, my lord, Article 31 was not suspended, only the later Article 31 remained. In the light of the above, it is pleaded, even as regards the function JK, permit the continuance of the JK Constitution. Parliament have immediate elections under the JK Constitution. They are specified. This is what I have to say. I'm sorry I've stepped over my time.
Thank you, Dr. Dhawan. Thank you very much, Doctor. Yeah.
But allow me to begin with this, Lord, profound words of Justice Aaron Barak, Lord, the President of the Israeli Supreme Court. Lord, he was reported in Harvard Law Review has way back in 2002. Since, Lord, we are expounding Constitution, these are extremely apt words. And I quote him, the task of expounding a Constitution is crucially different from that of construing a statute. A constitution is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power. Now, Lord, 370 is perhaps the most brilliant, Lord, articulation of statesmanship on the part of the constitutional framers. You are at a time when the Lord calls for plebiscite in Kashmir are being raised. You are at a time when raiders are raiding the Lord in plain clothes and trying to take away. You are at a time when Maharaja is uncertain whether he wants to join the dominion of India or Pakistan. You are at a time when Lord India is just being born as a Lord dominion nation. At a time like that, Lord, it was a brilliant compromise that was arrived at, which Lord led to Lord producing this article, which persuaded the people of Jammu and Kashmir to accede to India. We gave them a promise. You cannot Lord breach that promise in the manner that you have done, or for that matter, at any point of time. And that's why, Lord, what Dr. Dhawan very rightly points out, that Lord, ultimately, each Lord, article of the Constitution Lord, deals with this kind of diversity, which Lord, if we were to start tinkering with, then Lord, nothing will be left of the Constitution. So Lord, your Lordships may have to consider, Lord, and my respectful submission, three Lord submissions. One, that Article 370 is a piece of Lord, unusual Lord, draftsmanship. It is temporary, but it is not temporary by a flux of time as most temporary statutes are. It is temporary by object, the purpose. Once that object is achieved, once that purpose is subserved, then, Lord, nothing remains for the President to exercise. So, Lord, it's going to be my respectful submission that 373, Lord, has served its purpose the day Constituent Assembly of Jammu and Kashmir agreed that yes, Article 370 must remain on the Constitution of India, subject to following modification, and President accepted and issued that modification in CO 44. That's the end of the story. Lord, your lordships have taken the view right from federal court, and I will show Lord series of judgment that temporary statutes, Lord, General Clauses Act does not apply. If that is so, then Lord, the exercise is one-time exercise. You cannot exercise it again and again. It was never intended to be exercised again and again. Now, if it is not a continuing exercise on a demurrer, in my respectful submission, then Lord, the only way Parliament could do it is by amending the Constitution under Article 368 and repealing Article 370, and in no other manner. And I will show, Lord, that's the view, Lord, 8 of your lordships have taken in Berubari's case, where your lordships, Lord, interpreted a treaty and said that you cannot do this unless you amend the Constitution. And lastly, it's going to be my respectful submission for your lordship's kind acceptance that the exercise of powers by the President on 5th of August and 6th of August 2019, Lord, are nothing but fraud on the Constitution. As Dr. Dhawan rightly points out, there is nothing on record why a provision which has successfully survived from 25th October 1947 till Lord 6th of August 2019 should have been Lord repealed, as they claim, or should have been withdrawn. There was no material whatsoever. The only material with respects was that Lord, the ruling party in its manifesto in 2019 had said, we will abrogate Article 370. Your lordships in DC Wadhwa's case have said that you cannot exercise constitutional powers to achieve political ends. Lord, it's a classic case of fraud on Constitution. So, Lord, you have a government in Lord association with a local party in Jammu and Kashmir. It is working well. You suddenly withdraw the support from that government. Then you persuade the governor to issue president to issue a 356 order. Then you persuade president to issue a resolution of the assembly. Lord, Parliament then apparently takes control of legislative and executive functions, and then you say, now President will exercise all powers into one and Lord pass orders under 370. Lord, what more classic example of abuse of power than this can be? Lord, as Chief Justice Pope said, Lord, way back when the fight began with the king, that Lord, king can do everything except making a man a woman and a woman a man. Lord, surely President could not have exercised these powers under 373, assuming himself to be everything. What Lord has been pointed out at great pains and very brilliantly, that Lord 356 is a temporary provision. Now, Lord, 356 being a temporary situation, can you take actions which are permanent or permanency or permanent in nature? Forget anything else. Because Lord 356 itself says that everything that you have done in the interregnum will come to an end. And maximum period for which you can exercise 356 is 3 years. So, Lord, to do this, Lord, in my respectful submission, it really strikes at the very basic, Lord, features of our Constitution. Democracy, federalism, Lord, Government of India in their affidavit before your lordships categorically admits this, and this is very important, Lord, the counter, which I'll read at Lord appropriate stage, that Constituent Assembly of J&K did not in any manner deviate from the provisions of the Constitution of India, which would be applicable to J&K. This is their, Lord, profound statement. Then, Lord, they try and, Lord, they say that, Lord, ultimately, that what we have done is because of national interest. Therefore, nobody knows what this national interest is because it's not been defined in their counter affidavit. There was no material whatsoever. As I said, Lord, it has survived. Of course, there is insurgency. Nobody can deny that. But then we have insurgency in so many states in Northeast India. We had insurgency in Punjab for a long time. If we were to start not disintegrating states into union territories in this manner, no state will be safe in this, Lord, under political class that we have today. Tomorrow it may so happen that my party cannot get elected in a state. I will disintegrate into union territories because there is law and order problem. This is something which your lordships will have to very seriously consider. It's not just one-time exercise. It has such broad ramifications for future of India, for the Constitution of India, for federalism, for very existence. That, Lord, it will really be giving now this kind of a power to, Lord, a majoritarian government will be destructive of rule of law. It would be terribly destructive of rule of law. And I beseech your lordships, that's why in Coelho, your lordships have, Lord, very beautifully put it, that constitutionalism demands that your lordship should oversee every act of the parliament and the executive. And the moment your lordships will find that there is infraction of constitution, your lordships will come down heavily on them. It's all right to create, Lord, this atmosphere of fear all around. Nobody, Lord, one thing I must tell your lordships, very interesting, Lord, very few people, Lord, way back on 27th May 1949 in the Constituent Assembly, Lord, a debate was going on about bringing 4 representatives of J&K who had not been invited so far. Question was whether they should be nominated or not because everybody felt that they should be present. So, Lord, Mr. K.T. Shah, who was an advisor to government of Jammu and Kashmir and who had Professor K.T. Shah had worked there very extensively, he made this statement which was very interesting, which was perhaps quite inappropriate. He said, it has been the declaration of highest authority of India and also that of accession of the state made by the Maharaja, who was the complete constitutional head on the day that accession was agreed to, was subject to confirmation by result of plebiscite. Now, please see Pandit Jawaharlal Nehru's retort to that. Jawaharlal Nehru retorts by saying this is absolutely incorrect, 100% incorrect. I am amazed, surprised and astounded that such a statement is made by Professor Shah. Why? Because Kashmir had certainly become part of India and it will always be a part of India. Nobody denies that. Article Section 3 of the Jammu and Kashmir Constitution itself provides that we are part and parcel of India. Question is that when, Lord, you have now, Lord, as your lordships have very rightly questioned about sovereignty, Lord, you can acquire new land by either accession or by cession or by occupation. In each of these cases, my Lord, you can take away complete sovereignty, as my Lord the Chief Justice observed. But, my Lord, what happens in a situation like this, where you have agreed as a nation, as a dominion, as a state taking over that territory, that I take your territory subject to this condition? What happens there? There, my Lord, Derubari says that you cannot now get out of those conditions. And the only way you can do it is by amending the Constitution of India. Now, you don't want to amend the Constitution of India because then you have to follow the procedure. You need 2/3 majority in both houses. You may even need to go to the legislatures of the state because you are taking away representation of the state in Lok Sabha and Rajya Sabha. So you will need about 50% of the states to agree to that provision. So these are the safeguards. If these safeguards are thrown out of window in this light manner, who else can protect except your lordships? So it is very therefore important for us to understand that this is not just about Jammu and Kashmir. Jammu and Kashmir was, is and will always remain part of India. But the promise that India made to Jammu and Kashmir, the cession which came about on terms and conditions, how do you interpret those terms and conditions? So your lordships are called upon to expound this constitutional provision, which in my respectful submission is, and I must tell your lordships that Premnath, first, your lordship said that yes, we have to await the confirmation by the Constituent Assembly. I will show those passages. Then in Sampat Kumar, your lordship said, Constituent Assembly has given that assent. People have agreed to abide by this, and President has accepted. So both ways your lordship's court in these two judgments will not give a complete finality to what is the eventuality under Article 370, sub-Article 3. So in my respectful submission, this calls for a very different kind of approach than what government of India would like your lordships to take. That's an extremely, I would say it's a narrower approach. That's not how constitutions are interpreted. They have to be, these are durable provisions. They must go through the test of times. If merely because something has happened or is happening in Jammu and Kashmir, you have to do this, then it may happen in another state and you might be called upon to do that again. So the power cannot be exercised because of certain situation prevailing at a particular point of time. Constitutional provisions can't be tinkered with in that fashion. So how do you make them durable?
56
you make them
is not plenary in nature.
But the
it's
need
important
of the
to understand
that we wanted.
It is the bane of the Indian Constitution, my lord. It's introduced again and again and again.
So, my lord, at that point of time, we were left with no option but to accept what they offered us.
In fact,
we were afraid Maharaja might run away to
the Indian Law Institute.
There was one fear that he might go to Pakistan.
I was reading the 1935 debates, my lord, where Churchill interjects and says, create the situation in every single.
But who were the people who really were aware?
No, my lord, 356 has been used and abused to a point where there must be some discipline to it.
Of 370 is really
it is certainly not, my lord,
although, Lord, I am conscious
to amend
that
the
Constituent Assembly debates may or may not be relied upon as Lord, but it gives a complete answer to what government tells us on Lord 370. He also says that all that we need is the wishes of the people expressed through a Constituent Assembly. Once that wish is expressed, it's the end of the matter. He says that, and I'll read that two paragraphs of this. So, whichever way one looks at this provision in my respectful submission, this controversy needs a very, very delicate approach from your lordships, so that we do not end up creating a situation. Today, let us assume for the sake of argument that today this decision is in national interest. Let us assume for the sake of argument. Tomorrow, some other political party
transferring
majority may
executive and parliamentary functions. That is the power to legislate
you have
alone.
To therefore lay down law, which will stop all these exercises for all times to come. And that's where Constitution.
There are many provisions in the Constitution.
And I beseech your lordships with all humility and
where legislatures exercise many other kinds of powers as well.
Now take therefore
in this regard, powers of consultation.
Kindly turn straight away to one judgment of your Lord. I have
so it has to be limited, my lord.
Of judgments which are
otherwise, my lord.
But you can also.
What happened in the 5th August onwards, my lord?
Well, we can
happen to any other
already with Prasanna. I can add them with just in 1 second, if your lordships permit.
And that is why the broad proposition.
The existing compilation now? Powers, you said consultation, which were the other
It's
ones?
not with your lordships, it's
Lord,
with
I have a
the
list
Courtmaster,
here.
volume 30.
Article 3, for example, my lord.
130, case law.
So how do we conceptualize those other powers?
Case law compilation.
Volume 29, we stopped at volume 28. You said legislatures exercise other powers.
There are legislative powers which emanate from.
These are judgments.
Article 245, which says subject to the provisions of the Constitution. And it's important, my lord.
What are the other powers that you said? You said consultative.
Article 3 is a consultative power to express views. Article 54 is the right to vote in presidential elections. JK was not able to participate, my lord, in the last presidential election. Article 80 is to elect members to the Rajya Sabha. Article 169 is to pass a resolution for the creation of legislative councils in a state. Article 171, 243M, my lord. I'll come to those because I want to go into the question of the diversity of the Constitution.
243M.
Then, my lord, 243M. Then, of course, most important, my lord,
judgments are in the compilation?
Dr. Baba says.
Mr. Dave. Mr. Dave.
List of them I'll give it to you.
But 5 of them are
better. But the important part is it's limited to the legislative powers.
That's it, Mr. Dave, but at some point of time you have to freeze it all. Otherwise,
These are judgments. Your lordships can't certainly stop us from
cannot amend the
judgments.
Constitution.
Submissions, yes, I agree.
Or I'm going one step further, or deprive
the
the Constitution of its mandatory process.
And let me tell your lordships honestly.
It's an argument about
thinking process.
and
We are constantly thinking and constantly rethinking and rethinking and rethinking. Lord, to find 5 judgments, I have seen more than 500 judgments. I can assure you.
This is my submission,
if we apply this principle to ourselves on the lighter side, then we'll keep on thinking, not produce any judgment, and keep on thinking only.
Lord,
all that will happen.
Lord, your lordships, once
also the extension of
certainly will be thinking many a times over.
Done by Parliament.
At some time we have to also say, all right, now
this is fundamental, my lord, to how this process
arguments are beginning.
of diluting 370 occurred.
Judgments are repeated
And how Article 4,
not repeating, those are there. Those are there.
with all these incidental provisions which were limited to legislative
judgments which are already given, I am not.
Now, my lord, I wanted to get back to the point that I started with, my lord, about the diversity of the Indian Constitution.
Actually, the back office work has to be done before the arguments.
much before the arguments.
I'll quickly take your lordship's
The
through it.
problem is if you are a singular council arguing.
Lord, once the
Because your
debate
lordship
begins
is
in the court,
concerned
your
with how
lordships
this
put
diversity
questions.
can be
So,
preserved.
the way what happens is that's why if we don't do this, if essentially difficult
Borderland, my
matters will
lord, is
never get
mentioned in the
argued because
Constitution.
the whole purpose is to
Nagaland
restrict
has
time. If you don't
and
restrict
others
time,
have
you cannot
autonomous
carve out time
councils.
for big matters.
Well, take your
I have
lordship's through
promised
it.
1.5 to 2 hours, I'll finish it.
No, my lord, if this can be
I'm not
done,
going to take
in the
Mr.
president's
Dave, if you
rule,
were the only
anything can
council,
happen.
it doesn't really make so much of a difference. Because you added something, subtracted something. When the multiple councils, 10 councils, 12 councils,
What I've
each
done, my
person
lord,
starts
to
doing it. Where do we
save
go?
time,
This is the
is
concern.
I've prepared a list
It is
of
not
the
that we wanted to
articles
shut
Law
out.
declared
take us
by
to
this court,
diversity.
Lord, your
I'll
lordships
quickly
would
run
always
through
like
them
to see.
in the Constitution
It's law
itself.
declared by your lordships.
I know your
court,
lordship doesn't like paper being handed over.
I mean,
my
there
lord.
has to be a certain procedure also.
But we can put it on the
Orderliness in
website,
making
my
Every year, SEC online creates some 19, 20 volumes. This is another problem.
Well, I'm sure, Lord, when your lordships directed us to give submissions, we never thought that, Lord, so far as
because these are
judgments
only
are concerned,
articles of the
because it's a constant research.
Quite
Nobody
right.
cannot do it at
Lord,
one
it saves time.
You
It
are
saves time.
trying to find
That
out
permission
again
is
and again and
permissible.
again answers. Questions fall from your lordship's Lord bench. So, Lord, to that, your lordships rightly asked about sovereignty.
Because when your lordships didn't permit Mr. Sibbal to give supplementary submissions, I thought that's a harshness that might be imposed on handing
2
anything
volumes,
over to the court.
Ms. Dave.
I don't know, 29 is by...
29 is Mr. Nowadays. That is also.
No, my lord.
Not by the board.
Come to Article 2, my lord.
Then how many
This is
volumes will we
important,
have
my lord.
actually?
It is
We
endlessly-
should be actually having one volume now of case law.
28.
It's Parliament's
28 was
power
allowed already earlier, but 30
to
is
admit to
for
the
an
Union
additional
new
one.
states on such
Amendment.
terms and conditions as it thinks fit.
I have brought printed
This
copies
is
also.
very,
in
very
your notes,
different, my
So
lord,
volume 30 is 5 judgments.
5.
from the assimilation, my lord, of the princes, etc., into the constitution. That is, you go through an instrument of accession, you go through standstill, you go through merger, which then determines what is really entered into. Of course, my lord, in Podial's case, the majority judgment of Justice Venkatachalaya takes into account the entire history of the negotiations and says that although the constitution says one person, one vote, nevertheless we will permit reservations for Bhutias, Leptas and the South. In the context of that history, we will nevertheless permit it. And there were 2 dissents, my lord, by Chief Justice Sharma and Justice Agarwal. Now, Podial reminds us that these negotiations are important, even though it says as it thinks fit.
29
2A
also has this case law, right?
Yes,
in
yes.
the Constitution, because Sikkim was given associated statehood first. Now the Lord's kindly come to 3, which I've dealt with, 3 and 4.
All right, you can.
No, my apologies for it, but Lord,
Then, my Lord,
What
kindly come
sauce for
to
the goose is not sauce for the gander. So you
a
will not.
very interesting provision, my Lord,
I'm sure Lord Mr. Mehta will
when
definitely
we
like to cite
were
Lord, new
dealing
judgments
with
to counter
affirmative
us.
So
action.
he's
That's
not saying
Article
that I'm going to
35.
cite it. Don't give him ideas.
Lord, his smile tells us otherwise, Lord.
My learned friend has signed it.
What is it that you want to cite? All right, Mr. Dave, let's quickly run through it. Give us, give us those. Why didn't you give us the soft copy? Huh?
It's in the drive.
Hey.
Now, this is a very interesting provision, my Lord, relating to Article 16.3.
I would like to.
I'll just read it, my Lord, because it's important. Notwithstanding anything in this Constitution, Parliament shall have, and the legislature of a state shall
why don't
not
you then give the judgments and
power to make laws with respect to matters
give us the framework.
in Article
What are the judgments you want to
16.3,
cite?
32.3,
What is the principle? Just formulate the principle.
34,
As I
or
said,
for
Lord,
prescribing
three
punishment
points
for
that I
those
want to
acts which
urge.
are declared offences
One
under
is
this
that
part.
Lord 370
And
by
Parliament
itself,
shall,
Lord,
as soon
is a
after the